Thank you very much indeed. The timetable said that tea break ends at 3:15 and our talk starts at 3:30. So you might be wondering, what happens in that 15 minutes? I've got to tell you, I don't know the answer to that. But since we're here, and I think you're all here, obviously, we might as well start. We will try not to go over our half-hour slot, and I'll keep an eye on the time. But we have got a bit of leeway, so if anyone wants to ask questions, me a question at least, I don't have an answer, feel free to do so at any point. I'm just going to sit down. We're going to sit down because we've organised this talk incredibly badly so that we're each taking a couple of minutes a go or 5 minutes a go. So we're going to be swapping and it'd be too cumbersome to get up and stand up and sit down. So we're going to be sitting down. I hope everyone can hear and see okay. We can't see the slides, obviously. That it's not organised well enough to do that. But we're going to talk about the case of Dare against Solomon and Hikmet. And I was instructed by Farah's, I think they're here somewhere, for Mr. Solomon. Hopefully I was instructed for reasons other than the fact that my name sounds a lot like my client's. And Niran and Sophia, who you're going to hear from in a minute, were instructed for Mr. Hikmet. And in some ways, this was a classic post-termination restraint case where an employer was trying to enforce covenants and get an injunction and seek millions of pounds of damages and trying to stop the ex-employees starting for a new employer. But in other ways we're going to talk about, it raised some interesting issues. So most cases don't get to trial. Most cases don't even get to an interim hearing. So the way in which the judge dealt with the evidence and said how the evidence impacted upon post-termination restraints is quite interesting. And one key aspect of this case is absence and illness and how that impacts upon the enforceability of post-termination restraints. And that's what we're going to talk about today. The claimant company, Dare, is a trading organisation that trades its own money, proprietorial trading it's called, set up by two young guys, and they've done fantastically well. And it employed a whole bunch of other, mainly male, young people, earning ridiculous sums of money, just staggering amounts of money. So everyone had lots of money to throw at their legal teams, which is good. And it meant that the claimant was rich enough to pursue the litigation, and it meant that the employees were going to another entity, Onyx, who were rich enough to indemnify them. And so that was a perfect storm, amounts of money and people who are pretty bullish about their company being willing to litigate. I've just name-checked Niran and Sophia, and they weren't even in the room when I did that. That's gratitude. So unsurprisingly, given that the amounts of money that people were being paid was huge, the stress at work was pretty big too. And the evidence was that the employees were stressed and lots of them said they felt ill. And what happened was there was a slew of people who all resigned more or less at the same time and went to work. A lot of them went to work for a new employer, Onyx, doing a similar sort of thing, a competitor. And so this case, the Solomon and Hikmet case, was just one of many. And so I was instructed in other cases, and I can see people from Doyle Clayton sitting there who instructed me in another bit of Dare litigation that happened afterwards. But there were a whole load of Dare cases against ex-employees because they said, there's a conspiracy, you've all pretended to be ill, go off work and join our competitors. So this case in particular raises some interesting questions about PTRs, enforcement, enforceability, and springboard relief and tactics. And that's what we're going to talk about.
Thanks, Adam. So I'm conscious it's 3:30 in the afternoon. It's that point where energy might be flagging a little. And I'm sure you've sat through the facts of a lot of cases already today. So I thought I'd ease us in to this talk by taking you through the key facts of this case by telling a story through the pictures on the slide. So you know already that the claim was brought by Dare against two of its former senior traders, Mr. Solomon and Mr. Hickmet. And as Adam has said, there was a pretty intense working environment there. And during his employment, Mr. Solomon had complained about exhaustion and health issues. By November 2023, he decided he'd had enough, and he resigned to go and work in sunnier climes surrounded by the palm trees from Onyx's new office in Dubai. Now, he was expecting to spend his notice period tending to his garden with the watering can, the spade you see behind me. But instead, Dare decided that they wanted him to work his notice, and he was given a list of tasks to do to assist with handing over his work and knowledge during that period. And this unexpected request to work his notice caused, according to his medical evidence, a flare-up in a chronic health condition that he suffered from. So Mr. Solomon was signed off unfit from work by his doctor, who I think is waving from behind my back at you. While he was signed off sick, Mr. Solomon was, however, able to travel extensively, and he was able to go on nights out. You can see one of them on the slide. It looks like some kind of leisure centre disco, which I'm sure is just what he was going to. And Mr. Hickmet, turning to him, also resigned in February 2024, so a few months later, and a similar tale then ensued. So he also left to go and join Onyx in Dubai, although there was no evidence of any collusion or solicitation between himself and Mr. Solomon. Mr. Hickmet was also asked to work his notice period, and he was also then signed off sick during his notice period. Mr. Hickmet was signed off by his father's GP, who repeatedly signed him off despite the fact that he only had one consultation with Mr. Hickmet. Like Mr. Solomon, Mr. Hickmet travelled and went on holiday while he was signed off sick. Unlike Mr. Solomon, however, both before and during his notice period, Mr. Hickman shared some of Dare's confidential information and met up with various brokers and traders. So by early July 2024, Mr. Solomon and Mr. Hickmet had been signed off for some months, and Dare summarily terminated their employment at that point. And Dare then brought claims of breach of contract against them in respect of their refusal to work their notice periods, as well as enforcement of the PTRs, etc. And at the heart of the case was this dispute over whether they were genuinely too ill to work their notice periods, or whether their sickness absence had been contrived to avoid working during notice. Dare also sought injunctive relief to enforce their post-termination restrictions and, which takes us to the final picture on the slide, on a springboard basis to cancel out the advantage it said the defendants had gained from their breaches. And I know that's a diving board, not a springboard, but it's the best that I could do, so you'll have to bear with me on that. Now, against that background, I'm going to turn to look at how the court approached the question of the enforceability of the covenants in the case. In other words, the question of whether they were no wider than reasonably necessary to protect Dare's legitimate interests. Now, the defendants in this case were both subject to a series of 12-month post-termination restrictions. They each had a 12-month non-compete, non-solicit, non-deal and non-poach covenant. And they argued that all of those were unenforceable for various reasons, as well as arguing that even if they were enforceable in principle, as a matter of discretion, they shouldn't be enforced in the circumstances of the case. And Adam's going to pick up on that in the next section of the talk. Now, the court agreed with them that 12 months was too long in respect of the non-solicit, non-deal and non-poach, and that they were therefore unenforceable. But it found that 12 months wasn't too long in respect of the non-compete, and that was enforceable. The judge's views on why the non-compete was enforceable are notable for being, in my view, quite employer-friendly, which makes this case a useful authority for employers and those representing them. So firstly, the judge took a wide approach in considering whether there was confidential information justifying protection. So in these types of cases, where an employee's been exposed to vast amounts of often very detailed information through the course of their employment, as is often the case in financial services industries and other similar industries, there's often an argument over whether that information was sufficiently memorable to justify protection after the end of employment by way of a non-compete. In this case, the judge found that it was enough for Dare, the ex-employer, to show that at least some of the information which the defendants had been exposed to during employment could be dredged up from the recesses of their minds when useful. And that was enough to establish a legitimate interest. Now, that seems like a pretty low hurdle for an employer to clear. think you don't even need to show that an employee could be expected to memorise all or even most of the information they're exposed to, only that some of it might be buried away in the back of their mind. And secondly, the judge found that the 12-month period was justified, even though more junior traders were exposed to the same confidential information but only had 6-month non-competes. You might well think that that disparity in length of the covenants between senior and junior traders showed that the longer ones were unreasonable, as the defendants argued. But the court rejected that argument as well and found that the longer covenants for the defendants were justified because they reflected the fact that as senior traders, they were going to be better able to understand the confidential information and the value of it, to memorise it and to operationalise it for the benefit of a competitor. Now, I'm not convinced by this reasoning. It seems to me that you could well ask, why would a senior trader necessarily be better able to memorise information or to make use of it for a competitor? And even if there was some slight advantage that by virtue of their seniority they could do that to a greater extent than a junior employee, does that really justify a covenant of twice the length of the junior trader who had access to exactly the same confidential information? So again, it seems to me that the judge's approach here demonstrates a pretty employer-friendly approach, which makes DARE a useful authority to have in your repertoire if you're trying to enforce a covenant and there's an issue over the disparity of covenant lengths because other employees have shorter covenants compared to the one you're trying to enforce. So I've been talking about the issue of enforceability of covenants, and now Adam is going to look at the issue of enforcement.
Lottie's just been telling you how useful this case is for employers, but can I just say, we won. I hope that's not too much of a spoiler. And we won, I say we, the first defendant, won because of the question of enforcement. So the normal test in covenants, what Mrs. Justice Cox called the 3-stage test in TFS, is working out what the covenant means, identifying the legitimate business interest, and the third stage is making sure that it's no further than is reasonable to protect that legitimate business interest. That's what she called the 3-stage test. But there is a fourth stage, a fourth element, and that's the key here, and that's discretion. So even if the covenant is potentially enforceable as a matter of law, should the court enforce it and grant injunctive relief? The normal answer is yes. The standard approach in enforcing negative covenants is that the normal response of the court will be to grant an injunction. The case on this, leading case on this, is what was initially reported as DVP, or Dyson and Pelleray, as it's now reported, where the court says that the usual order is to enforce a negative covenant, don't compete, don't deal with our clients, don't solicit them, and don't poach our employees. Unless you can show, you being the ex-employee, that you would suffer exceptional hardship. And that's a very high hurdle. In this case, DARE was paying some money, I mean, for normal people, lots of money, but not for traders, some money during the period of restraint. So it would be very difficult to show that there was exceptional hardship. This case was different. We said, the defendants, both the defendants said, because of the absence from work and the undertakings they'd given after they'd been terminated to the court pending the trial, DARE had in effect had the 12 months protection that they would have got if the covenant had been enforced. So the question for the court was, did that make any difference? DARE said it's an outrage to run this argument. It would encourage a practice whereby employees would assert they were too sick to work, thereby not only avoiding work in their notice periods, but then also claiming that the court shouldn't enforce their restrictive covenants. A cheat's charter of this kind would be contrary to public interest, and the court should unhesitatingly reject it. The court hesitated. it accepted our argument for the first defendant who was ill, but not for the second defendant. And the two big differences between the two parties were, one, Mr. Solomon was genuinely ill and Mr. Hikmet wasn't too ill to work, and two, that what Mr. Hikmet had done was some acts in preparation to compete. He'd misused some confidential information by giving it to Onyx, and he'd failed to do a handover when he should have done had he been at work, but he was swinging the lead because he wasn't ill. So those are the factual differences, and this is what the court said. The court said, I refuse relief against Mr. Solomon, the first defendant, because Dare has already enjoyed protection against competition for more than 12 months, but granted relief for the whole of the period against Mr. Hikmet. So the rationale appears to be a person in breach gets enforced again, a person not in breach who's genuinely ill doesn't get enforced against. Fine, that feels right, you might think. But what difference, actually, does it make why you're off work? The normal rationale for enforcing a non-compete covenant, well, there are two rationales. One is to police the enforcement of the other covenants, but as Lottie has indicated, only the non-compete was upheld and held to be potentially enforceable in this case. And the second basis is to protect confidential information. That's the reason why you have a covenant against preventing competition. But the reality was, the basic reality for both defendants, they'd basically been out of work. They out of the workspace, and they didn't really have any more access to confidential information than anyone else who'd be out of the workspace, and Mr. Hikmet didn't really have any more access than Mr. Solomon. So what difference does it make that there was a breach by Mr. Hikmet? This isn't really explained by the judge, but he upholds the covenant. And it's not as if this was all springboard relief. Because springboard relief is because of your wrongdoing, you've gained a competitive advantage. But this is awarded as covenant relief, which isn't based on a competitive advantage. So there was no obvious analysis. It seems that the court effectively decided people in breach don't get my discretion exercised in their favour, and people who are genuinely ill do get my discretion exercised in their favour. As far as we know, this is the first case where sickness absence has impacted on enforcement of a covenant in this manner. I say that nervously, looking around at the huge amount of knowledge in this room, but I think that's the position. So you might assume that because the covenant was not enforced by the court, that would be the end of it. But you sorely misjudge quite how much fun the parties were having in litigating. So once we got the judgment, the first thing that Dare did was write to my solicitors and say, well, we've got an enforceable covenant, albeit it's not going to be enforced by injunction, and therefore it's an enforceable contractual term. You, Mr. Solomon, can't start work for Onyx because that would be in breach of the covenant, and we're going to sue you for damages, and our damages could be £1 bazillion or whatever figure they came up with. That's an interesting argument. Mr. Solomon responded saying that's obviously wrong, that you've had all the protection you need, because that's why the court didn't enforce. You've had the 12 months, and there's obviously no loss flowing from a covenant that kicks in after you no longer need any protection. And you know, what is the loss flowing from a non-compete covenant unless you can show actual misuse of confidential information, for example? It's not clear what their loss would be. But unfortunately for lawyers, all the claims settled after judgment was handed down, so we never got to litigate this particular point.
So Adam's mentioned springboard relief there, explaining that that wasn't the basis on which Dare was trying to uphold the covenants. But they did seek springboard relief to cancel out advantages which they said the defendants had gained from their breaches, including in particular advantages they said they'd gained from their failure to work their notice period. And as the court noted in Dare, and as Adam's alluded to already, there's no authority. This is another area where there's no authority or prior authority that the parties were aware of in respect of seeking springboard relief in these circumstances. So this case raises, again, some really interesting questions about the boundaries of the springboard doctrine. Just as a reminder, before we look at how Dare argued it in this case, the origin of the springboard doctrine is in confidential information claims to remedy misuse of confidential information. But in the case of UBS and Vestra, which is up on the slide, amongst other cases, it was made clear that springboard relief isn't confined only to confidential information cases, and it can be available in other employee competition cases as well. In the UBS case, that was a team move. And what the court said in UBS was that springboard relief is available wherever former employees have taken unfair advantage of serious breaches of the employment contract and thereby obtained an unfair head start. So the focus of springboard relief is on cancelling out the advantage that's been gained as a result of breaches. And it's incumbent on a claimant to show that advantage is ongoing and to spell out the precise period for which that advantage will last. They also have to show the nature of that advantage. What was unusual about the Dare case was that the main breach that Dare was relying on for its springboard relief claim wasn't the usual sort of competitive activity that you see typically in springboard cases. So, usually you'll see misuse of confidential information or encouraging colleagues to join a team move, that sort of behaviour. But here, the breach they were focusing on was their failure to work notice. Now, not working your notice period isn't an obviously competitive thing to do. It's not something that you could say only an employee who's seeking to compete with their former employer would do. In fact, I suspect the majority of employees would rather be put on paid garden leave than working out their notice period, regardless of what their plans are on termination of employment. So the case raised the question of whether the type of breach is relevant to a claim for springboard relief. It also raised the question of what a claimant needs to show in order to satisfy the unfair advantage criterion. So in this case, what Dare argued was that the defendant's failure to work notice gave them an unfair advantage in two ways. Firstly, it meant they ended up leaving Dare earlier than they would otherwise have done because their notice periods their employment was terminated during their notice period. And that meant that they could join Onyx earlier than they would have done. And secondly, that Dare was deprived of their services during the time they say they should have been working notice, which forced Dare to reallocate resources and caused business disruption. So the question there was whether this was enough to show that the defendants had obtained an unfair advantage from not working their notice. Now, Dare's claim in this respect failed and was rejected by the court. Now, in respect of Mr. Solomon, we, of course, already know that the court found that his sickness absence was genuine, and so he wasn't in breach of contract by failing to work his notice. And with no breach of contract, that was the end of the claim for springboard relief against him. But we know that the court found that Mr. Hikmet was in breach by failing to work his notice, yet it also refused to order springboard relief against him in respect of that breach. I should say it did order 1 month springboard relief in respect of his other breaches to do with using confidential information and solicitation. The court's reasoning on why it wouldn't order springboard relief for failure to work notice is quite short. It comes right at the end of a very long judgment, but despite its brevity, nonetheless, the reasons that are given are interesting for us to dissect. At the heart of the decision was focus on the purpose of springboard relief being to prevent the exploitation of a breach of contract to gain an unfair advantage. And as set out on the slide, the judge stated that he was doubtful that the springboard doctrine could apply in these circumstances, as it's predicated on an employee taking an unfair advantage by his unlawful conduct. The main focus, therefore, is on the actual advantage gained by the wrongdoer. So he wasn't persuaded that the defendants had gained the advantages which Dare alleged. And he said again it was doubtful whether these were even the kinds of unfair advantage that the springboard doctrine should embrace. So in terms of the alleged advantage from early termination, which you remember Dare said that meant they could join Onyx earlier, The judge said that that was far too speculative to find to be an advantage, given a lack of evidence on the reasons for termination and the possibility that the defendant's employment would have ended early in any event by Dare bringing it to an end early. With regard to the argument that the defendants had gained an advantage because Dare was left in this sort of weakened state as a result of their failure to work notice, the judge said, well, in essence, that's just another way of describing the disadvantage caused to Dare, which was simply matters of quantum for damages. And he said, as damages would be an adequate remedy, there's no injunctive relief would be appropriate. So if we step back and look at what this judgment sort of tells us about trying to push the springboard doctrine to bring in these kinds of breaches, it seems that the difficulty with claiming springboard relief for breaches of contract which aren't obviously competitive in nature, which is what Dare were doing here, is that it's going to be hard to persuade the court that those breaches have led to the type of unfair advantage required. And it probably stands to reason that where an employee's breached their contract for some reason other than just to compete with their employer, as we're saying here, there might be a whole number of reasons why an employee doesn't want to work their notice period, it's likely to be harder to show that they've gained some kind of competitive head start from that breach. And certainly what the judgment seems to tell us is that it's not going to be enough for a claimant to argue simply that we've had disruption to our business and that's enough to show that there's been an unfair head start. And on that note, I'll pass over to Adam to finish up our talk with discussion of tactics.
Thanks, Lottie. So we've got some questions about what tactics to pursue. And the first is absence. So the first defendant was genuinely ill and therefore couldn't work. The second defendant was not genuinely ill and so by extension could have worked. And the claimant's evidence was that we would have got him trading again. And that's pretty strange evidence because one would assume you know that your employee is going to a competitor and you want to stop them having access to your highly prized confidential information. But that was it. That was their evidence. And the judge accepted it, that's what the judge did. So he was in breach and potentially, the claimant said, we would have made millions of pounds had you been trading. So the slide asks, should you use absence as a tactic? So on balance, given that it could create millions of pounds of liability and costs for your client, my gut feeling was that you should not advise your client to pretend to be ill. But you are going to hear from Mr. Hickmett's legal team and they may disagree. But the real question is what happens with medical evidence? And that's the real issue in this case. And that's where it made some interesting findings. The judge said, I think correctly, the court and an employer cannot go behind medical evidence unless there's good reason to do so. So if you're for an employee and you've got some form of medical evidence to show they're ill, that's probably enough. If you're for an employer, think carefully about whether or not you want to get medical evidence, because you could be undermining the employment relationship by accusing them of lying. But if you might have a contractual right to get medical evidence, and if there is contrary medical evidence, that gives you the opportunity to challenge it. But the starting point is the court cannot go behind medical evidence. Now, the picture that Lottie showed you of the doctor earlier on, I think that was in fact Mr. Hickmett's own doctor. Yeah. Secondly, garden leave. Should you put someone on garden leave? This is a really pro-employer judgment in this respect. So what the judge says was, as a matter of law, there's no requirement to have a set-off in the post-termination restraint for garden leave. And so in other words, you've got a 12-month, say, garden leave provision that you're allowed to exercise, plus a 12-month post-termination restraint. That could effectively keep an employee out for 2 years. And the judge said, there's no need to have a set-off. Now, he didn't analyse this particularly with reference to any of the cases. My view is the better, more sensible approach if you're drafting covenants to have a set off for garden leave. I think that is much more robust. And there are various cases which indicate that. It's correct that there's no case in which a post-termination restraint was held to be unenforceable because of the lack of set off for garden leave. But I'm not sure that goes quite as far as what the judge seems to say in this case. But for employers, it's pretty solid, a pretty solid basis for thinking that there's no downside to putting your employees on garden leave and not having a set-off provision. Obviously, if you put them on garden leave, you have to pay them and you don't get their work, or at least you may not, depending on the terms of the garden leave clause. When should you dismiss? Now, in this case, what happened was Dare, about 3 months before the end of their notice, summarily terminated the 2 employees and paid in lieu of notice. What advantage did that give them, though? Now, I struggled to see any advantage from that decision, because they paid the salary they would have had to pay in any event. And what the effect was to bring forward the period of post-termination restraint. So the PTR started from the date of termination, and they artificially advanced that. Now, one rationale for doing it may be because they wanted to capture matters that had taken place in the retrospective or look-back period. So a post-termination restraint often has a provision whereby dealings in the last 12 months of employment are prohibited in the post-termination restrained period. And it may be that's what they had in mind, but I couldn't personally see any great advantage. And I think if I'd been, or if I were advising now an employer in that position, I would just say keep them on, keep them employed. Should you sue the new employer? Is that the next one? Yeah. But it depends. Is that enough? Lottie and I did a great case called Jump.
As Niran.
And Niran. And Sophia. We all involved in Jump as well. Sorry. It was a great case where Lottie and I were acting for the new employer. In that case, the ex-employer had said that the new employer was liable for inducing a breach of contract, and our position was we genuinely thought the covenants were unenforceable and had evidence to show that. And so the case against us was vanishingly slim, almost non-existent. So we were sued in that case, and I think we caused a lot of trouble just by turning up for the claimants. So I wouldn't have sued us if I'd been advising the claimant in that case. In this case, they didn't sue the new employer. Is that my stomach rumbling? They didn't sue the new employer, but there was lots of evidence that the new employer had been intermingling and conspiring with the outgoing employees to do wrongdoing. So they didn't sue them in this case, but maybe they should have done. The answer is it depends on the evidence, and it depends on what remedy you're seeking, but think carefully about whether or not to sue them. And lastly, what remedy to seek. Now, in this case, they sought everything they could possibly seek. So they sought breach of contract, breach of fiduciary duty, enforcement of PTRs, springboard relief, restitutionary damages for salary paid, that's an interesting one, and declaratory relief. And all that they succeeded against my client was showing that he was in breach of contract for not going to occupational health. Although, as the judge correctly identified in the judgment, that probably led to nominal damages at most. So should they have gone for all of that? I think the answer is don't overplay your hand. Declaratory relief in particular isn't a magic bullet if you're not going to get home on other matters. So I think the declaration at the end was advanced by Dare because they wanted to try and remedy the position on costs. Now, unfortunately, we didn't get to a cost hearing. My view is we had definitely got our costs paid by the claimant. But what the claimant was saying was, well, we won on enforceability, so we're entitled to a declaration, which is something of value and importance to us. And the judge refused to give it. We haven't got a reasoned judgment on that, but the final order was simply that there was no declaration. So declaratory relief is often sought by claimants as a sort of magic bullet to try and bring a claim against ex-employees. And my view is you've got to think very carefully about that, and you might come unstuck, especially on costs if you over-egg your hand. Thank you. I think we've finished with 5 minutes to go. So without more, I will introduce Mr. De Silva and Sophia Berry, who are talking to you about disclosure matters.
We move on